Hello, viewers. Hello, ladies. Hello, gentlemen. Hello, good people of Nigeria and the world over. Welcome to this episode of Forgetting How to Forget and Remembering How to Remember, the Fhtf, the Rhtr podcast. Today, we have a most curious topic. For a piece like this, one of the first things that you think of is why. Why is a topic like this important? In fact, why is a topic like this necessary? What do we expect to learn from it? In truth, we'll get to find out some of these things as we go on, but I would also like to set the tone because that way I believe that I will help you and us digest some of the more hidden themes in the story that we're about to share. Today, on this episode, we intend to discuss the landmark case of Gani Fawehinmi versus Sani Abacha. And I'll tell you why. You see, information is a tool. Information is not an end in itself. It informs, it shapes, and it dictates. But you see, when the information that you have on something is inaccurate or is skewed or is propagandized, basically when the information you have is faulty, then there's a very high likelihood that whatever conclusion you shall come to, no matter how studious or well-meaning, will also be faulty. And one thing that we can take to the bank, at least one thing that we have tried to communicate as much as we have been able to on this podcast, is that whenever we get information from worldwide sources, in quotes, about Africa, about Nigeria, about the black race in general, there is always a bias somewhere that we need to pick out. There is always a lie. There is always some misinformation we have to decipher. So, we need to remember this case because the fact that this case even exists at all tells a story that, as far as general consensus goes, should not exist. This is one of Nigeria's most foremost lawyers in history taking a military administrator, not just a military administrator, but the top military administrator in the Nigerian military regime, to court, to a Nigerian court. Right off the bat, one of the themes that we are trying to communicate with this episode, and I hope we're successful, is that with the stories that we have heard about what a military regime should look like, this should not be possible. But we'll get there. For now, let us first of all look at the facts. Let's look at the case itself, and then let us look at the significance of the Gani Fawehinmi case against General Sani Abacha. Nigeria, as we know, has gone through several phases of military rule. In fact, thankfully, because of the Fourth Republic, which we are in now, it is difficult for most people to remember, but there was a time where we had gone through more military rule than we had civilian rule. In fact, between 1983 and 1999, I do not think we had as many as 5 years of civilian rule. But it is instructive to say at this point that whenever this military took over power, there was, as my lecturer would say then, a quiet celebration that the military had come to sweep away the corrupt civilian governments that were not doing their jobs. But this never did last. It was always like a party. Immediately after the music was done, then you had to face silence. And the silence of military rule was always brutish, it was nasty, and life was short. And so they would want civilian rule again. General Sani Abacha became the military ruler of Nigeria in the 90s, in 1993 to be precise. He was the military ruler of Nigeria from 1993 to 1998. And depending on who you ask, those years represented some of the most brutal years that Nigeria has ever faced in terms of a military dictatorship. In fact, some people will tell you that the years Abacha spent in office are responsible for the bad image that Nigerian military dictatorships have today. That's a story for another day. How did this case come about? One of the ways this case came about is something I would like to pitch in before we go. There were rumors when General Sani Abacha was alive and when he was head of state that he was in the process, or he had the ambition of transitioning himself from a military head of state to a civilian ruler. And these were not just rumors. There were reports, there were letters, and indeed, it was all but confirmed that he did have this ambition. For this reason, it puts into perspective some of the moves that were made by his administration. Because one of the very first things that you notice if you look at the Abacha administration from afar is that he was quite ruthless in terms of doing away with political opposition, whether by prison or by disappearance or outright death. Some of the names that are on the roll of that administration are names that are very familiar to Nigerians, especially those of us who watch this podcast. People like Kudirat Abiola, the wife of the late MKO Abiola. People like Chief Alfred Rewani, Chief Mrs. Bisoye Tejocho, Alhaja Suliat Adedeji, and Dr. Shola Omoshola were some of the people that were mysteriously assassinated or disappeared during that regime. And it was not just limited to civilians. Admiral Babatunde Elegbede retired, fell to the same fate, and so did Admiral Ulu Omotenwa. In short, the list of people that had their fundamental human rights trampled upon during the Abacha years is a very long list. And that is how we come to Chief Gani Fawehinmi. But before we even get to him, we need to mention one more thing. In terms of trampling upon rights, there were certain people that stood up to this regime. Certain factions, certain organizations that in terms of trampling upon rights, there were certain people that stood up to this regime, whether directly or indirectly. So, for example, Ken Saro-Wiwa and the Ogoni Nine are some of the people that we remember that did not bow to this. former president of Nigeria, Olusegun Obasanjo, is one of those people. And he was imprisoned, for example. One of the things that we will come to see as we continue along the story is that there was no shortage of motivation for the government of that time, which is the Abacha government, to clamp down on his supposed detractors, especially because a lot of those detractors happen to be people who could later on come to hurt him politically. Like, for example, Chief Olusegun Obasanjo, who I just mentioned. And as I said, trampling on fundamental human rights. Here comes the African Charter on Human and People's Rights. The African Charter on Human and People's Rights guarantees civil and political rights, such as the right to liberty, to fair hearing, and to freedom of expression. It also guarantees economic and social rights, such as right to education and right to health. And then it guarantees people's rights, such as the right to self-determination and right to the environment. Right off the bat, some of these issues seem very difficult to bring into Nigerian law. The right to a safe environment, the right to education, the right to health, they are not really things that are particularly embedded in our law. But that is exactly why we had the African Charter for Human and People's Rights, because it was a document that, and mind you, Nigeria, as the giant of Africa, pushed very hard to get completed. We're involved in the drafting of this document, we're involved in advertising this document and getting other countries to sign this document. And by 1983, when it was time, we were one of the first people to sign it. Now, at this point, I should explain a couple of concepts. When an international document or an international law is to be brought into Nigerian law, there are a couple of things that must happen, a couple of hurdles that we must step over. First of all, the law has to be signed. What it means for a law to be signed is Nigeria as a country has to declare its intention and its knowledge of the law. Oh, we have seen this law, we like this law, and we probably want to be a part of it. Then we ratify it. Ratification involves looking at the law, taking the parts of it that we believe are compatible with our law, and then turning it into a document that we can now take and say, this is how we are going to accept the law. And then we domesticate it. By domesticating it, it means that we take that document and pass it through our National Assembly the same way that an act that originated here would have gone, therefore making it Nigerian law. So it is no longer a foreign document, it is now a Nigerian document. Those are the three steps. You sign it, you ratify it, and then you domesticate it, or as some people will say, you indigenalize it. So why was this a problem? Well, this was a problem because all of this was done by Nigeria way before Abacha came into power. In fact, we adopted the law in 1981. We domesticated it in 1983. And as a part of its domestication, it came into force in Nigeria as the African Charter on Human and People's Rights Ratification and Enforcement Act in 1986. That is 7 years before Abacha became our military dictator. Nigeria was already a country that had on its books a law with the spirit of the African Charter on Human and People's Rights. But, as we have established, General Sani Abacha was not a fan of people who disrupted his government with protests or with demonstrations or with any kind of opposition. Therefore, Chief Gani Fawehinmi was arrested in 1998 by agents of the government. He was arrested during a protest that was being carried out against military rule, and he was detained under the State Security Detention of Persons Decree number 2 of 1984, which authorized indefinite detention of individuals considered a threat to state security. This decree basically is a law that said the government has come into power, and since the military government is in power, the military government and its laws and dictates will take precedence over every other law of the land. In other words, the decree contained an ouster clause, and the ouster clause stripped Nigerian courts of jurisdiction not only to hear cases against the decree, but to even allow for any challenge of the decree in a Nigerian court. So obviously, Chief Gani Fawehinmi could not go through those means. But for anybody who knows the name Chief Gani Fawehinmi, you would know that he was a brilliant man. In fact, he's one of the most brilliant lawyers that Nigeria has ever produced. And therefore, that was not going to stop him. And since it was not going to stop him, he found another way to go after the government or to defend himself from the government. And the way that he found was he challenged his detention, arguing that it violated his fundamental human rights as guaranteed by the African Charter on Human and People's Rights. Now, this was interesting because, of course, nobody had ever done that before. That is why this is a landmark case. He argued that according to Article 5, which was his right to dignity of human person, he had been violated. According to Article 6, which was the right to liberty and security of the person, he had been violated. According to Article 7, which was the right to have a fair trial, he had been violated. And according to Article 9, which was the right to freedom of expression, he had also been unfairly treated. This matter was heard, and eventually it rose to the Supreme Court, which is the apex court of the land. And the questions that were brought before the court centrally was, what is the status of the African Charter in a Nigerian legal system? That is, what value should be placed on this law? What hierarchy should be given to this law as far as the Nigerian legal system is concerned? There were three issues for determination. The first issue was whether the African Charter on Human Rights, being domesticated by the National Assembly, was part of Nigerian law and directly enforceable in domestic courts. The answer is yes. It's a resounding yes. There is no reason that a Nigerian law, which is what it was at the time, could not be binding in Nigerian courts. But the court still had to ask the question anyway. The second issue was whether the African Charter enjoyed supremacy over conflicting domestic laws and military decrees. And this was the more tricky question. Because if the African Charter had been domesticated, which it had been, then it had become like any other Nigerian law. And by virtue of the decree, the African Charter would be lower in hierarchy to the decree. But the court was determined to answer this question. The third issue for determination was whether the Nigerian courts retained the jurisdiction to intervene in matters that were authorized by this decree number 2. Both parties argued, of course. And just as an aside, it's interesting when things like this happen because you understand that lawyers have no choice but to bring forth arguments, even when they do not feel as though their arguments are as sound as they should be. But it is their job to represent both sides. Because looking at the facts of the case, there is very little that the Abacha side could have had to argue about. But they still had to pay dues. So, of course, we are going to come with something. Chief Gani Fawehinmi argued that the African Charter, by virtue of its domestication, it made it a part of Nigerian law and therefore was binding on every Nigerian, including state authorities, which the head of state was one of them. That's bold, isn't it? And the Abacha camp argued that Nigeria operates a dualist system where a treaty or an international law that we imbibe does not have the same force as Nigerian law. This, like I say, was a funny argument, but they had to argue something. The judgment came, and it came from the great Waifo. They also had concurring judgments from Ogundare JSC and Ayola JSC. And in the judgment, the court ruled that, and I should read this, the African Charter, having been domesticated, forms part of Nigerian law and is enforceable in Nigerian courts. Like we said, that is very simple. Two, it also says that the African Charter guarantees rights that individuals may directly invoke before Nigerian courts without any additional legislative enactment. Three, here's where it gets tricky. The court ruled that, however, during military rule, decrees were supreme in the legal hierarchy. And in the case of inconsistencies between a decree and the African Charter, the decree prevailed. By the letter of this, you would think that that was the end of the case. Because if the decree, and not if, the decree said that you cannot challenge it in the Nigerian court, and it takes precedence over every other law. And the African Charter on Human and People's Rights Enforcement Act was a law of Nigeria, and therefore that was supposed to happen. But then the court went further again and said, despite that general principle above, where the decree is supposed to take precedence, the court ruled that the detention of Chief Gani Fawehinmi was unlawful and it unjustifiably violated his rights as guaranteed under the African Charter. Therefore, he was awarded 10 million naira in damages for the violation of his fundamental human rights. Just so we know, 10 million naira back then was a lot of money. But this is interesting, and I will tell you why this is interesting. While a lot of people went about hailing this case and talking about how fantastic this case was and its impact on the rule of law and how it showed the true position of judicial empowerment in a civilized society, there is a lot about it that people can reflect on. In fact, great scholars like Ben Wabuizi and Richard Akinola and Abiola Sani have given their fair share of opinions about this particular case. But they've answered the questions academically. That's not why we're here in this podcast. In this podcast, we tend to want to ask the questions mischievously, if I may say. For example, the court has already ruled that the decree takes precedence. If the decree takes precedence, how did the court also rule that the rights of Chief Gani Fawehinmi were violated, and therefore he was due damages. The only way to answer this question is where we put on our conspiracy caps, or as they would call it, our tin for your hats. Let's ask this question differently. The judgment of this case was given in 2000, even though Chief Gani Fawehinmi brought it in 1998. It was given in 2000, 2 years after General Sani Abacha had passed on. So here's the question. Would this still have been the judgment if General Sani Abacha did not pass on? I know it's a strange question, but think about it. Were he still to be the military administrator of Nigeria, would the courts have been brave enough to say, in the face of a military dictator, that although your decree states that you cannot be challenged, you have trampled on the fundamental human rights of this great man, and therefore you will award him damages? I will not answer that question, even though I think you know my answer. Second question. There are holes in the Nigerian constitution. As a matter of fact, if you ask anybody who takes the constitution seriously as a matter of study, they will tell you that the Nigerian constitution has too much of a military flair to it. That is, there are too many elements of military rule that made their way into the Nigerian constitution. It's not really our fault. It was partly drafted by the Nigerian military. But because of that, there are several questions that the constitution does not answer. This is one of those questions. For example, ask a lawyer you know. We call them fundamental human rights. But technically, as far as the Nigerian constitution is concerned, fundamental human rights do not operate the same way that we think they do. We watch movies, we see in film, and we think that fundamental human rights are somehow the highest kind of law that you can appeal to. That is not really the case. In fact, the very existence of the government is evidence that your fundamental human rights are secondary. But we will come to that another time. The third question. There is something called the doctrine of natural justice, equity, and good conscience. It is not a law, but it is something that judges use. Sometimes you could be in court and everything is against you, but the judges can tell that you acted in good faith, and the judges can tell that the person beside you is trying to use the law as a weapon to cheat you. And because of the doctrine of natural justice, equity, and good conscience, the court can find a way to make it not so bad for you. The question is, even though the court did not mention this principle when they gave their judgment, is this principle enough to wash away bad law? In some cases, yes. But in this particular case, is it something that could have been relied upon? And that is why it is interesting looking at this case. Because on one hand, this case can be looked at as a great lawyer challenging a military administration. And on the other hand, it can be looked at as a military administration with ambitions to become a civilian administration, responding as it would if it were a civilian administration. I know that sounded a little crazy, but follow me on this. You see, life under military rule was not clear cut. There were two things that were sure. The first is, it was not a democratic government. Under military rule, you could not just decide that you wanted to go and vote. There were no tenures, they were military administrators, and basically, when they gave orders, people followed. Second, it was, in a way, totalitarian. Whatever law was given by the military ruler was the law of the day. In fact, if you would remember, and if you don't remember, you should look for this. One of the most famous speeches ever given in Nigeria's history was given by this same General Sani Abacha, and it is called the Abacha Dissolved Speech. You should go and look for it. It is where he sat down and he talked about how the military government had taken over. And then he said, one after the other, the Nigerian constitution has been dissolved, the National Assembly has been dissolved, the offices of the governor dissolved, this dissolved, that dissolved. That decree, just by his mentioning of it, is more powerful than every other law that existed at the time. And you would have to understand that it is something like this that Chief Gani Fawehinmi was fighting against. In simple black and white terms, Chief Gani Fawehinmi was basically saying to a supreme ruler, I am challenging your supremacy. When you look at it that way, it wasn't the easiest thing for him to do. You could even say it wasn't the smartest thing, but it was brave. It was damn brave. And there were reasons to be afraid of a military dictatorship. There were reasons to be afraid of the Abacha government. When the Okuta panel was conducted, one of the very famous episodes in the human rights hearing was a testimony given by one Sergeant Rogers. And Sergeant Rogers gave the confession as one of the hitmen of the Abacha administration. And he gave details, he gave times, he gave places, he gave techniques and methods that were used to hunt down and persecute individuals that were against the government of General Sani Abacha. We'll cover that in another episode. But that is something you can go and look out for if you want to understand just how brutal and how decisive this government was. Bravery is a virtue. Chief Gani Fawehinmi was brave. And he wasn't the only brave person, I must say. We have called a couple of names before. And they went about it. These names that I called, they went about their bravery in a most sophisticated manner. They just didn't protest, they just didn't demonstrate. They went to international fora, they submitted letters, they put petitions forward, they brought evidence to the world to see that this is what was going on in Nigeria. The movement for the survival of the Ogoni peoples, for example, MUSOP, is one of those platforms. The National Democratic Coalition, NADECO, is one of those platforms. The National Liberation Coalition, NALICON, is one of those platforms. And from those institutions, we have names like Chief Anthony Enahoro, Chief Adekunle Ajasin, and Ken Saro-Wiwa. All these names are famous today for many things, but one of the things they are famous for is how they stood up to the systemic and the cunning ways with which they approached danger, because that is what it was. It was danger that they fought against. And then again, we come to a point where we have to look at this story holistically. Chief Gani Fawehinmi protested against the military rule of Sani Abacha. Sani Abacha caught and imprisoned him. Chief Gani Fawehinmi challenged the constitutionality of his capture and detainment, and the court ruled in his favor that truly his fundamental human rights had been violated. The question we ask on this podcast is, would that have still been the case if these other factors did not change? That's a question we may never have an answer to. What we do have an answer to is that judgment was given in favor of Chief Gani Fawehinmi, and if for any reason, God forbid, we find ourselves in a similar situation down the years, there is precedent to look to. There's a lot about military rule that we need to clarify. Why do military rulers in Nigeria even exist in the first place? Why is there such a vacuum in Nigerian law where people with boots and camouflage can walk into the government house and seize power and run the government instead of the democracy that we think we have? For those of us who got the chance to live through military rule, albeit shortly, we understand some of the hardships and we saw some of the totalitarianism that went about. But we really don't know as much except for what we read or what we hear. But like we said at the top of the show, what we read and what we hear is coming from a source, and we have to scrutinize those sources. In every military rule, we are told to assume that there is no such thing as fundamental human rights. With this case, it doesn't seem so black and white any longer. We are told that there's no separation of powers. With this case, it doesn't seem so black and white any longer. We are told that there is no freedom whatsoever. But studying this landmark decision, there seems to be a little bit of leeway that was given. Basically, I welcome anybody to please not be carried away, because we live in a time where we romanticize a lot of things. You may have heard, I know I have heard many a person say maybe the military should just take over and we'll be better off for it. I hope they know what they're saying. I hope they understand the implications of those wishes, because those were the wishes of people in the 80s and in the 90s. And those same people today, if you ask them, will tell you they do not want a military government. But for people like us, who never got to suffer through them, we can romanticize a bit. Should we? I'll end by saying this. There is a statement, and I'm not sure who to attribute it to, that the worst civilian government is better than the best military government. If there is any truth to that statement, then we should simply take lessons from cases like this and hope that we are never in the position to teach lessons of our own. But with that being said, I would like us to applaud the person of Chief Gani Fawehinmi, and understand the significance of what it was he was able to accomplish with this case. If you studied law in Nigeria, his name is like a shadow that goes over every faculty of law in this nation, and rightly so. He is a giant of a man. In the field of law, he is a titan. Things like this is why we remember him, and things like this is what we should never forget. Thank you very much for being with us on this episode. See you another time.